Chapter 19. Domicil in particular places. Domicil of foreigners in France. SS 341. Art. 13 of the French Code Civil. The question has arisen, can a foreigner without authorization establish his domicil in a country whose laws provide for authorization by the government of that country to establish domicil there? And upon this question there has been considerable discussion and difference of opinion. It has particularly arisen under the French law, in the construction and application of art. 13 of the Code Civil, which is as follows: the foreigner who shall have been admitted by the government to establish his domicil in France shall enjoy there all civil rights so long as he shall continue to reside there. Two remarks must be premised: that prior to the adoption of the French Code the right of a foreigner to acquire in France a domicil carrying with it all the incidents which usually belong to international domicil was universally recognized, and that there is not in the French Code, or in any of the French positive laws, any express provision which prohibits a foreigner from acquiring a domicil in that country without authorization. Whatever is found in the Code upon the subject is found by implication, and mainly, according to most of the authorities, in the article above quoted. SS 342. The difficulty attending the subject largely one of method. If, therefore, the question is considered by what appears to be the more logical method, namely, by first inquiring whether a foreigner may establish a domicil in France without authorization, leaving the legal consequences of such domicil for subsequent determination, there would seem to be little or no doubt that an affirmative answer should be given, the ancient law on the subject having been as we have seen it, and there existing in the French law no prohibition against the establishment in that country of a domicil by a foreigner in the ordinary way, facto et nemo. But unfortunately the French jurists have followed the very illogical method of considering whether a person can, without authorization, acquire a domicil for this or that particular purpose, e.g., domicil for the purpose of succession, etc., thereby confusing in a single inquiry both the constitution and the legal effects of domicil. It is to this method of inquiry and the confusion of ideas consequent thereupon that the great perplexity and conflict of opinion which have apparently surrounded the subject are mainly due. It is not for an American text writer, even if the scope of this work permitted a sufficiently extended examination of the subject, to attempt to reconcile the conflicting views of French jurists concerning French law. It will be sufficient to point out briefly and generally some of the different opinions which have been held by the courts and text writers of that country, and then to consider the views held by the courts of this country and Great Britain. Apology for occupying even so much space as is here devoted to the subject is found in the fact that already a number of cases have arisen in the English and American courts in which have been discussed the true construction and legal effect of art. 13. In the further fact that, by reason of the large and increasing number of Englishmen and Americans resident in France, the Anglo-American courts are likely to have frequent occasion to turn their attention again and again to the subject. SS 343. Various opinions held in France that a foreigner cannot establish a domicil in that country even with authorization. In France, according to Domicil, three general opinions have been maintained. First, that a foreigner cannot in any case establish a domicil in that country, either with or without authorization. This view, which is clearly inadmissible, inasmuch as it is equally opposed to all international change of domicil, seems to be based upon the theory that a foreigner, no matter how apparently permanent may be his establishment in France, must be presumed always to intend sooner or later to return to his native country, unless he has actually and formally become a French citizen by naturalization. We have already seen that there is a strong presumption against an international change of domicil, and this is based mainly upon the well-known habits and feelings of men, inducing them generally, in spite of prolonged residence and apparently permanent interests in foreign lands, to retain the animus revertendi, but to carry it to the extent of conclusiveness is to ignore the equally well-known fact that in modern times very many persons do, without seeking naturalization, voluntarily establish themselves in foreign countries without the slightest intention or hope of return. Those who hold this extreme doctrine are probably led to it in part by a consideration of the very serious consequences attending the establishment of a Frenchman in a foreign land sans esprit de retour. SS 344. ID. That a foreigner may establish a domicil in France only with authorization. The second opinion is that a veritable domicile cannot be established by a foreigner in France without authorization. It has the sanction of many distinguished names among the French jurists, and is supported by various arguments, among which are the following. It is said that, in general, French laws are made for Frenchmen only and not for foreigners, and in particular, art. 102, which defines domicile, contemplates only the domicile of Frenchmen. Le domicile de tout francais, quant à l'exercice de ses droits civils, est au lieu le son principal établissement, and the articles which follow, construed with art. 102, provide only for the ascertainment of the domicile of Frenchmen. Furthermore, although a foreigner may establish himself during a long period in France and in a manner apparently fixed and stable, yet in truth his residence cannot be said to be permanent, inasmuch as he may at any time be sent out of the country by the government. Authorization is indeed revocable, but it, nevertheless, gives a certain security in fact, and is a guarantee which it is natural to seek when a person wishes to permanently establish himself. Again, domicile is itself a civil right and is art. 13, which is the only one that treats of the domicile of foreigners, contemplates authorization as a condition precedent to the enjoyment by them of civil rights. It follows, by necessary implication, that domicile cannot be acquired without it. It is said substantially, further, that is art. 13 plainly contemplates that without authorization permanent establishment in France shall not carry with it the full legal consequences which follow when authorization is added, and as a supposed domicile, which does not carry with it all the legal consequences of domicile, properly so called, cannot be a true domicile. Therefore, while a permanent establishment by a foreigner in France is susceptible of certain consequences, it is not to be construed as a true or veritable domicile. The distinction is hence taken between a domicile de fait and a veritable or legal domicile. SS 345. ID. And finally, the advocates of this theory fortify their reasoning by what they consider authoritative utterances upon the subject. They cite first the language of the Orateur du Tribunat in his discours at the sitting of the Cour Legislative of 17 Ventos, and 11 when art. 13 was under discussion, which was as follows. J'ai observé sur l'article 13 qu'il n'y eu aucune objection contre la disposition qui veut que l'étranger ne puisse établir son domicile en France. Est-il n'y est admis par le gouvernement? Si est une mesure de police et de cher aucune disposition législative. Le gouvernement s'en servira pour repousser le vice et pour accueillir exclusivement les hommes vertueux et utiles, ceux qui offrent des garanties à leur famille adoptée. They cite also an avis du Conseil d'État as follows. Le Conseil est d'avis que, dans tous les cas où un étranger veut s'établir en France, il est tenu d'obtenir la permission du gouvernement. These authorities, they say, conclusively establish their position. SS 346. ID. That a foreigner may establish a domicile in France without authorization. The third opinion is that a foreigner may establish a domicile in France without authorization. This view also has the sanction of a number of distinguished names among French jurists, and is supported as follows. Its advocates rely, first of all, upon the customary law of France as it stood before the adoption of the Code, and they contend that there is no provision to be found in the Code which ordains, expressly or by fair implication, otherwise. On the contrary, Art. 102 expressly fixes domicile at the place of the principal establishment, and it cannot be doubted that a foreigner may have his principal establishment in France. If it be said that Art. 102 contemplates only the domicile of the franchise, it is answered that the history of the preparation and adoption of that article shows that the purpose was to distinguish, not between the domicile of Frenchmen and foreigners, but between political and civil domicile. The original draft declared the domicile of the citoyen to be the place where he may exercise his political rights, and that of other individuals, such as unmarried females or widows, who do not enjoy the political rights of the citoyen, to be the place where the individual has fixed his principal establishment, the word citoyen being manifestly used in the sense of citoyen active. The form which was definitively adopted after discussion was therefore intended to remove the distinction between the citoyen and other individuals so far as concerns the determination of domicile for civil purposes, and not to draw any distinction between Frenchmen and foreigners. If the latter had been the intention, some traces of it would have remained in the discussions, which is not the case. But admitting that Art. 102 relates solely to Frenchmen and not to foreigners, and that no principle can be drawn therefrom even by analogy, we are then thrown back upon Art. 13 is the only one in the code having any reference to the domicile of the latter, and this has for its object to determine not in what cases a foreigner may or may not be domiciled in France, but in what cases he may enjoy their civil rights. If the former object had been intended, it would have been very easy to have expressed it, and that the latter object was intended is shown not only by the text itself, but also by the fact that the article appears under the title treating exclusively of the enjoyment and privation of civil rights. SS 347. ID. With respect to the avis du conseil, relied upon by the advocates of the second opinion, it is said by those who uphold the third, that it was intended solely for the guidance of the Minister of the Interior, to whose inquiry it was a reply, that it was never inserted in the Bulletin of Laws, or legally published in any manner, and has therefore no binding force upon the tribunals, and that, although the language of the avis is broad, it must be construed with reference to the subject matter of the inquiry to which it was a reply, namely, whether under the provisions of Art. 3 of the Constitutional Act of 22 Frimaire, and 8, a foreigner could become a French citizen without having received authorization to establish his domicile in France. The words of the Tribune Gary also, it is said, are to be restrained to the subject matter under discussion at the time they were uttered, namely, the acquisition of civil rights by foreigners, and are not to be taken in their general and unrestricted sense. It was the language of Gary and the avis du conseil d'etat which constrained Merlin, in the 4th edition of his repertoire, in spite of his own evident opinion to the contrary, to adopt the view that authorization is necessary for the establishment of a domicile proprement dit in France by a foreigner. In his 5th edition, however, finding that these authorities were otherwise explicable, he rewrote his section on this subject, and adopted and enforced by various arguments the opposite view. Such are the most prominent arguments advanced by the French text writers in support of the several principal views on this subject. SS 348. Decisions of the French courts. It is impossible to examine here in detail the decisions of the French courts. They are numerous, and in some instances apparently irreconcilable. It is sufficient to say that in spite of considerable conflict existing in them, there is a large preponderance, particularly among the later cases, in favor of the opinion that a foreigner can acquire a true domicile, or domicile de droit only by virtue of authorization, but that without authorization he may acquire a domicile de fait, carrying with it a part of the legal consequences generally produced by domicile de droit. But this preponderance, although great, cannot be looked upon as conclusively settling the question, inasmuch as in France far less respect is paid to judicial decisions as determinative of the law than in this country and Great Britain. And, moreover, it is well known that the French Court of Cassation has at different times changed its opinion in matters of private international law. The question therefore naturally arises, whether, when the subject which we have been considering comes before a British or an American tribunal for adjudication, it is bound to adopt the view at the time prevailing in the French Court of Cassation, or whether it should take the existing French legislation, and with the best lights available independently construe it. SS 349. English cases. Collier v. Rivas. In England, the subject has been considered in several cases. The first case was Collier v. Rivas, which involved the validity of certain codicils to the will of one whose domicile of origin was Irish, but who had subsequently acquired an English domicile, and still later had settled in Belgium, where he continued to reside up to the time of his death, without, however, obtaining authorization. The codicils were executed in accordance with the law of England, and not in accordance with that of Belgium. Sir Herbert Jenner held that the facts clearly showed the testator to be domiciled at the time of death in Belgium, that therefore the English court sitting to determine the validity of his testamentary dispositions must consider itself as sitting in Belgium, and must apply the same law that the courts of that country would be bound to apply, and that inasmuch as the Code Napoleon conferred full civil rights on those foreigners only who had received authority from the king to establish their domicile there, and as therefore the succession of a foreigner who had not obtained such authority must be determined by the laws of his own country, it followed that the codicils in question were valid, because executed in accordance with the laws of England, where the testator was last domiciled before coming to Belgium. The construction put by the learned judge upon the provisions of the Code Napoleon was based upon the testimony of 2 Dutch lawyers, and has been criticized and dissented from in subsequent cases. SS 350, ID, Anderson v. Landonville was the case of one who, being Irish by origin, had acquired a domicile in England, and subsequently went to France, and there resided without having received authorization for 13 years, under circumstances which were deemed sufficient to show permanent establishment. He left 2 wills, one executed in England in accordance with the English law, and the other, which was the later of the 2, in France in accordance with the French law. The question was as to the validity of the latter will in point of formal execution. The case was first heard by Sir John Dodson, who held the testator to be domiciled in France, and his will, executed in accordance with the laws of that country, valid. Upon appeal, this decision was affirmed by the Privy Council, but although the point was distinctly raised by counsel in the appellate court that the testator could not have a domicile in France by reason of his failure to obtain authorization, it was not discussed in the judgment. The point was, however, in effect decided against him. SS 351, ID, Bremer v. Freeman. In Bremer v. Freeman, the subject was considered fully and with great care, and with the assistance of a number of the most eminent lawyers of France, who testified with regard to the French law. The question was in this case also as to the formal execution of a will. The testatrix, whose domicile of origin was English, had resided in France a number of years under circumstances which in the opinion of the Judicial Committee were clearly sufficient for a change of domicile, but without having obtained authorization for the purpose. She died, leaving a will executed in France according to the English law, and not in accordance with the requirements of the French law. The case was first heard by Sir John Dodson, who, although holding the testatrix domiciled in France according to the Jus Gentium, decided against the validity of the will on the ground of want of authorization. But his decision was, on appeal, reversed by the Privy Council. The judgment was delivered by Lord Wensleydale, who, after finding the evidence of the French law produced to be very unsatisfactory, confused, and conflicting, proceeded to make an independent examination of the French authorities, including judicial decisions and text writers, and after a careful review, arrived at the conclusion that no authorization is necessary for the establishment of domicile by a foreigner in France, at least for the purpose of succession, that the testatrix was domiciled in that country both at the time of her death and at the time of that law, and therefore the 13th article, besides that of the validity of the will, did not deprive him of them. But the Madame de Vane, a natural daughter court, expressly decided that he might of the testator, cited the legatees before making the will in question, and that therefore the will was invalid. It was further held that the failure of the testatrix to procure authorization, and the fact of her making her will in English form, were some evidence that she did not mean to abandon her English domicile. Yet they were of little weight, as it was highly probable that she knew nothing of the provisions of the Code Napoleon, or of the necessity of making her will in any but the ordinary English form. It must be observed that so far as concerns the testimony of the French lawyers, the case was much complicated by the views which they advanced with respect to the rule applicable for the determination of the validity of the will in point of formal execution, the witnesses for the appellant holding to the maxim locus regit actum, and the majority of those examined by respondent holding a will in the form required by the law of either the domicile of origin or the place where the party dwells to be valid. All of these views, however, being rejected by the court as inconsistent with the English decisions. Moreover, Lord Wensleydale expressly declares the reliance of their lordships upon the opinions of the law entertained by the expert witnesses of the respondent to be somewhat diminished by the fact that the latter held, in opposition to the clear opinion of their lordships, that the facts shown were insufficient to prove the establishment in France of even a de facto domicile by the deceased. Subsequently, an unsuccessful attempt was made to oppose the practical execution of the sentence in this case, by tendering proof that the Privy Council had erred in its exposition of the law of France. To this end was procured the sworn statement of 10 of the most eminent advocates of the French bar, to the effect that upon the admitted facts they were positively of the opinion that according to the French law the deceased had never acquired in France a domicile of a nature to cause her testament, or the form of her testament, to be ruled by the laws of that country, and that consequently If that testament was made in conformity with the English law, the deceased would not be judged to have died intestate. But this statement, which was ex parte in its character and made after sentence pronounced, was not permitted to be produced before the Privy Council. SS 352, ID, Hodgson v. de Beauchesne. The question was again raised in Hodgson v. de Beauchesne. Sir John Dodson, upon the authority of Bremer v. Freeman, and in spite of the testimony of French lawyers, held the deceased, who had not obtained authorization from the French government, to be domiciled in France. His decision was reversed on appeal by the Privy Council, but the reversal was put upon the ground that the evidence did not sufficiently make out the requisite animus menendi, the failure of the deceased to obtain authorization being relied upon, however, as one circumstance to show that his establishment in France was not permanent. While this case cannot be considered as direct authority upon the subject here discussed, it is important because of some remarkable language used by Dr. Lushington in delivering the judgment of the Privy Council. He said, in solving these difficulties we must always look to the jus gentium. This proposition, however true, requires some explanation. The tribunal which tries a question of this description is necessarily bound by the law of the country in which it is situate, and by which it is constituted. That law, whatever it may be, it must necessarily obey, but it is not bound to respect the laws of a foreign country save so far as they are in accordance with the jus gentium. SS 353, ID, Hamilton v. Dallas. The question again arose in Hamilton v. Dallas, a case of intestate succession and legacy duty. The deceased, Lord Howden, was established in France for 16 years prior to his death, under circumstances which left no doubt of his intention of permanent residence there, but he had not procured authorization. The case was heard by Bacon v. C., who, after carefully considering the authorities, and referring particularly to the latest French cases, said, under these circumstances, I entertain no doubt whatever upon the question which has been argued. I have no doubt of Lord Howden's competency to acquire a French domicile. I have no doubt that he did acquire that domicile, beyond all possibility of question. He therefore held that the portion of the estate of Lord Howden, which was undisposed of by will, was distributable according to the French law, and was not subject to legacy duty. He, however, also concluded that Art. 13, neither in its terms, nor in its sense and spirit, has anything to do with the rights of the person who comes to claim the property at a time when he and all droit civils to be exercised by him are extinguished and gone, thus holding, in effect, that personal succession concerns the rights, not of the deceased, but of those in the line of succession. SS 354, Results of the English Cases. It is clear from the above cases that the English courts will hold that a foreigner may, without authorization, establish in France a domicile in the sense in which that term is ordinarily understood in English jurisprudence, and that, as they at present understand the French law, a person so domiciled will, with respect to his succession in his testamentary acts, be subject to the same law as a French citizen domiciled in France. SS 355, American Cases, Dupuy v. Wirtz. In this country, the New York Court of Appeals, in Dupuy v. Wirtz, while holding upon general principles that the deceased, who at the time of her death resided in France, had retained her original New York domicile, and that, therefore, her will executed in conformity to the laws of that state was valid, considered the question whether she could without authorization establish in France a domicile which would subject her, in matters of personal succession, to the laws of that country, and, upon the sole authority of Melizet case, arrived at a negative conclusion. It was further held by the court that the failure of the testatrix to obtain authorization was a circumstance to be considered, along with other circumstances tending to show the absence of the animus requisite for the establishment of a French domicile. SS 356, ID, Harold v. Harold. The subject was somewhat considered in the New Jersey case of Harold v. Harold, in which a French woman, the widow of an American who had resided in France, where also he had been married to her, claimed community of goods under the French law. The precise question in the case was, however, one of matrimonial domicile, which is not, at least as understood in this country, necessarily domicile at all, but intended domicile, and is resorted to for the purpose of ascertaining the intention of the parties with reference to their mutual property rights. But the actual domicile of the parties, and particularly that of the husband at the time of marriage and immediately afterwards, is often an important element in determining the matrimonial domicile, and was so used in this case. The court, therefore, held that the domicile of the deceased who had not obtained authorization was by the jus gentium in France, and thus arrived at the location in that country of the matrimonial domicile, and the consequent subjection of the husband's property to the French law of community. SS 357. Are the consequences of authorization personal, or do they extend to wife and family? A further question is raised among French jurists, namely, whether the legal consequences of authorization are strictly personal to the foreigner himself who obtains it, or whether they extend also to his wife and infant children. Zachary holds the latter position, while Domicil holds the contrary, remarking that if a foreigner desires authorization for his whole family, it is permissible for him to ask for it. However, upon the principles established in our jurisprudence with respect to domicile and to naturalization, it seems hardly conceivable that our courts could do otherwise than hold that wife and children are included in the authorization, unless, perhaps, in case it is, by the terms of the authorization, expressly provided otherwise. Domicile in Eastern countries. SS 358. Different rules for the determination of domicile applicable to Eastern and to Western countries. The principles which we have been considering are applied usually with reference to the countries in which European civilization prevails, to wit, the Christian countries of the world. Are they also applicable to countries in which such civilization does not prevail? In other words, will an American or European court hold an American or European person to be domiciled in Turkey or China, or one of the barbarous countries of Africa? And if so, will it apply the same rules for the determination of the establishment of domicile in the latter class of countries as in the former? A negative answer to the latter question needs no argument to support it. It is apparent to everyone that, for example, the presumption against the establishment by an Englishman of his domicile in France or Italy is not nearly so strong as that against the establishment by the same person of his domicile in Turkey or China, and that fewer and less cogent facts would suffice as proof in the one case than in the other. In an oft-quoted passage in the Indian Chief, Lord Stowell says, "In the western parts of the world alien merchants mix in the society of the natives. Access and intermixture are permitted, and they become incorporated to almost the full extent. But in the East, from the oldest times, an admissible character has been kept up. Foreigners are not admitted into the general body and mass of the society of the nation. They continue strangers and sojourners as all their fathers were, doris amara suum non intermiscuit undam, not acquiring any national character under the general sovereignty of the country, and not trading under any recognized authority of their own original country. They have been held to derive their present character from that of the association or factory under whose protection they live and carry on their trade." SS 359. ID. Maltas v. Maltas. In Maltas v. Maltas, the deceased, born at Smyrna, of English parents, continued to reside there, with the exception of a few years of his boyhood passed in England for the purpose of education, up to his death. He engaged in trade at Smyrna, married there, and at his death left his family there residing. The Turkish law not conferring upon those subject to it the power of testacy. The question in the case was whether the will of the deceased was valid. Dr. Lushington held that it was, but although considering the deceased domiciled in England, he held that to be immaterial, inasmuch as, if domiciled in Turkey, the English law was applicable by virtue of the treaties between Great Britain and the Porte, and, if domiciled in England, the same law was applicable propria vigor. The learned judge added this language: "I give no opinion, therefore, whether a British subject can or cannot acquire a Turkish domicile. But this I must say, I think every presumption is against the intention of British Christian subjects voluntarily becoming domiciled in the dominions of the Porte. As to British subjects, originally Mussulman, as in the East Indies, or becoming Mussulman, the same reasoning does not apply to them as Lord Stowell has said does apply in cases of a total and entire difference of religion, customs, and habits." SS 360. Can an American or European acquire a domicile in an Eastern country? Read Toodle's Trusts. In the very recent case of Toodle's trusts, the English Court of Chancery has had occasion to consider the subject of domicile at a Chinese treaty port. T, whose domicile of origin was English, went to Shanghai in 1862, where he became extensively engaged in newspaper and printing business, and where he continued to reside, with the exception of several visits to England for health and business, up to his death in 1878. In his will he described himself as of Shanghai in the Empire of China. Evidence, which was uncontradicted, was adduced showing that for some years before his death he had determined to reside permanently at Shanghai, and had relinquished all intention of ever returning to England. Under these circumstances, counsel who opposed the English domicile admitted that they could not contend that the testator's domicile was Chinese, and this admission was held by Chitty, J., who decided the case to have been rightly made. Counsel, however, set up the theory of an Anglo-Chinese domicile, an analogy to Anglo-Indian domicile, upon the ground of the existence at Shanghai of an English community under treaty stipulations. But the court repudiated this theory and held the domicile of the testator to be English. SS 361 ID. Here, then, we have, according to the uncontradicted evidence, complete abandonment of the English domicile of origin and residence in China with intention to remain there permanently. If this case is to be accepted as an authority upon this point, therefore, something more is necessary for the establishment by an American or a European of his domicile in a country in which European civilization does not prevail, than abandonment of his domicile of origin and mere residence with intention to remain permanently. What more is necessary has never been pointed out, although, doubtless, as Dr. Lushington intimates, a change of religion would be deemed sufficient.